Hello, everybody. Welcome on in. Hopefully, you guys are having a wonderful Friday. It is Friday. Hold on just a second. Sorry, guys. Hold on one second. Okay, sorry about that. I'm so sorry. It's good to see everybody. Teddy Max said I'm in the bath. I just got out of the bath, actually. That's why I'm not on camera because I'm still doing the things that girls need to do to get ready, Putting my face care on. Doing my face is what they say, I guess. No, my hair is soaking wet. I ran my dogs out before the live started to get them a little walk in, and I didn't realize how long we were going to be on our walk. So I've just been rushing around. But we've got Friday today. We have Bryan Kohberger back in court today. We've got a lot of stuff going on. So he will be in court. He's already been in court this morning. They went to court earlier this morning, and now they're going to have another hearing at 1 p.m. That's going to be open to the public, 1 p.m. Pacific time. So it'll be 4 p.m. our time. The court is going to hold their second hearing, and it's going to address the separate motions from the defense, which is asking the judge to reconsider his previous refusal to dismiss the indictment for inaccurate instructions to the grand jury. So the motion argues that the grand jury should have been told to find proof beyond a reasonable doubt rather than the current Idaho law, which states the grand jury only has to find Actually, I'm just going to read it. The grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by trial jury. And that's what they did. I think that they're probably going to, he's probably going to say, try again later. But we'll see. We'll see. So thank you guys all for being here today. If you guys haven't hit the like button, please do so. It's free to do. It's free. And of course, Isabel, it's her 9 p.m. her time. So good evening. Good evening. I'm so Jan. Good evening, Isabel. I read Jan's thing there, her little post. And if you'd like to become a member of our channel, we'd love to have you here. So I'm going to show you just a couple things before court starts. I have Alex Capriello pulled up for News Nation. I have the John Judge website for YouTube. And then I also have Court TV, and I have WFLA. So we are good to go over here. We're good to go. So let's pull this up. I just wanted to, I went over to the Gonzalez's family page before I came on the live because I wanted to see if they had posted anything for today. And they did. It was just a simple little message, but they did come out and do an interview, and they told the person in the interview pretty much how Kaylee was found, like how she was found, what position she was in. And so we'll go over that as well. I was very surprised that they actually came out and was saying stuff. So let's see. Let's see here over here. So it just says here, good morning, everyone. We're getting ready to head down to Moscow for court. Please say a prayer that the judge sets a scheduling order for trial. And that's really what they want. In this interview that they did, they were talking about how if the judge doesn't set a trial date today, they may have to wait until next summer, and they don't want to have to do that. I guess they're kind of maybe thinking if it has to be a summer trial. So I'll read over this and then we'll discuss it and let me know what you guys think. So Bryan Kohberger, the suspect, is it? I pulled up. Okay, I do. Just making sure. Bryan Kohberger, the suspect in the University of Idaho student murders, is due in court Friday, which that's today. This as the parents of one of the victims releases new images of their daughter the family recently got from investigators. The parents of Kaylee Gonzalez sat down with ABC News for an exclusive interview, sharing never-before-released images of her, their 21-year-old daughter, who was one of 4 college students brutally stabbed in an off-campus housing in Moscow, Idaho. However, the family is still waiting on a full digital copy of Kaylee's phone from authorities. We're just left in limbo, said Kaylee's dad, Steve Gonzalez. These are the last moments of your child's life, and you're just sitting here fighting with somebody who just doesn't care. They were able to collect some of Kaylee's belongings from the university over the summer, which raised concerns for them about how well possible evidence was processed. And this is what got me. You guys all know how I feel about that trash on the backside of that porch. I've been talking about it since I first laid eyes on it. Well, This is what they received: a trash can from Kaylee's room. It says, including a trash can from Kaylee's room that was full and appeared untouched. Like, what are we doing? Are we afraid to touch trash? Get some gloves on like old Kohberger. You'll be fine. It says here, we opened it and there was a little squeezy applesauce thing that like you would give to a toddler. It did not appear to have been gone through, Kaylee's mom, Steve Gonzalez, said. Police said they had gathered more than 100 pieces of physical evidence from the scene, along with some 4,000 photos and 3D scans of the residence. Still, frustration is mounting for the family over what they considered a lack of communication in a rush to tear down the home on King Road. Christy describes for the first time how Kaylee was found. And this, I was like, wow. It made me, man, it makes me feel so bad that they have this image of their daughter in their head. But it says here, the side where Kaylee was up against the wall. And you can imagine Kaylee in an upright sort of position, up in the corner, slumped. So she was in the corner of, actually, I have it right here. That's crazy. I have it like pulled up. Let me just get into the room. So yeah, like you can see where the arrow is right there. That's pointing downward. So she would have been in that corner. Of course, that's what we assume. We assume she was on that side. But so she would have been up in this corner. Which to me says maybe almost like she was trying to get away from him. Like backing herself up into the corner, just trying to get away. And then she was slumped down. Slumped over. It says, I mean, she was trapped. She described the bed. The bed was the entire room. You could barely open the door without swiping the foot of the bed. And it was wall to wall, you know. The headboard was up against the wall. So, yeah, it's very sad. Because, you know, if you know if you know what the images are, you're going to, every time you close your eyes, you know what I mean? That's sad. It's very sad. It just says, you know, prosecutors asked for Kohberger's trial to be set. Let's see what's going on over here on WFLA. So, and then I'm going to refresh Judge John Judge's tab. Okay, nope, nothing yet. Okie dokie. We'll go over to WFLA. I was going to see what Alex Caparello said at first, or first before we went over. Because it says he was live streaming with JB, but he's not over there anymore. Okay. What is he trying to do over here? Alex Capriello. It says they're trying to decide. It says trying to decide how to best cover this Bryan Kohberger hearing. There is no live tweeting inside the courtroom, but I can very well sit outside the courtroom, watch the live stream, and live tweet what I hear. Is that something you guys would want to see? I will have a producer monitoring Kohberger's behavior from inside who can fill me in once the hearing is over. He's like, I'm just trying to get it to you. I'm just trying to get it to you fast. Maybe. I think that Xana knew too what was happening also. It's so sad. The whole situation's sad. And then, I mean, even on the other side of it, you know, the coin there, Bryan Kohberger's mom and dad. I don't think they knew what, you know, their son allegedly that he did this, you know, what he was capable of. I think that they probably knew he had done some stuff in the past, like steal his sister's cell phone, do some stuff like that. But I don't think they had any clue that he would, you know, be to this like level. But yeah, we'll switch it over. We'll watch some JB. We'll see what's going on over here. They got 10,000 people watching over here. So let's see. And then I'll make sure that I keep my eye on the courtroom as well. And I'm pretty sure that that's probably where they're going to play it here as well. So, and welcome in everybody. If you're just now joining us, we're going to watch WFLA, see what they're talking about here about Bryan Kohberger in about 10 or 12 minutes. Court is supposed to start, but you know, court usually starts a little late.
like that. But we've seen other Idaho courts do this.
I'm just gonna fast forward.
Familia, we got your question coming up. It's right there on screen. We won't forget about you. But really quickly, Emily, I just want to ask you, if you're Judge,
Well, let me get my face out of.
you are very
Ladies.
cognizant of the fact that this is a high profile national/international case. Does that change how much of his normal behavior and normal patterns and normal decision-making process as a judge get influenced by the fact that this is commanding so much attention?
One would hope not much.
Right.
You would hope that you just get a slice of regular court, and the same way you would if it was of intense local interest, even not international interest. But I imagine judges choosing to do things a bit more methodically, knowing that it is going to be streamed and discussed. How could you not? And so I don't know if it's this judge's normal practice to not rule from the bench. He waits and does written motions, but they're very thorough written orders. And get the sense that that is his normal practice, that he is thoughtful, he takes things under submission, and then puts out a written order sometime later. And I don't think that's changed because of the streaming. But of course, they're cognizant of it because courts have to deal with all of the intense floods of emails that the courts get about the case. They have to deal with other attorneys like myself talking about the case. They have people in their lives that are watching this coverage being like, I saw you on TV today. It's a very different thing. Most of the judges and lawyers that I know would never wish that their normal court workday be on a stream like this. It is not comfortable for anyone involved, and most attorneys don't become attorneys to be on TV. A few do, but most don't.
But at the same time, can't help but wonder if when our legal system is under the microscope with a case like this, as much as it is, if it almost serves as a litmus test for the mainstream public to say and ask themselves, does our justice system work? Like, is this what we're doing here in the United States? Is this working? Are we actually doing this thing called justice correctly? And so I always wonder about the mindset of judges when it comes to whether it's Murdoch or whether it's Petito or whether it's this particular case. Familia Christie wants to know, do you think that this is a case that will go cold due to huge media coverage? Do you think that outside influence could slow things? I think is what Familia is asking here, Emily.
Familia, normally I associate cold with being unsolved. So
Right, me too.
I don't think there's going to be, any meddling in that way until we get to trial, and then we're going to see the things we've seen in other high profile cases with people on Reddit saying that they're jurors when they're not actually jurors and that sort of things. But I don't think it's going to be unsolved. The prosecution considers this case to be solved and prosecutable. I don't think the media attention changes that. I think what cases like this do is help the public understand how our system works, which is slowly, sometimes methodically, and sometimes in a very frustrating manner. The victims' families have to be tremendously frustrated with how much is under seal because they don't know what's going on either. And feeling like you're on the outside in a case involving your child, I don't know if there's much that could be worse than that. So this is frustrating for the public, but also for those involved immediately in this case. And it's why we've seen victims get attorneys. But no, I don't think it's going to go cold. I think it's going to be slow.
One more question from me and one more from William here, and that's it for the Q&A. William wants to know, is there evidence that you think that we don't know about yet?
William, I love this question. I don't normally give percentages when I talk about law, but I'm going to give you one today. 100% there's a lot we don't know in this case.
And
absolutely 100%.
How did you know that I was going to ask you in this next question for a percentage? Did you I don't know if you read my mind or not, but
I absolutely read your mind. It's hard law to give percentages, but again, I was a prosecutor for over 10 years. There's so much that we do not know about this case. We know the scantest amount of information from really the probable cause affidavit and the arguments over DNA. That's all we know in this case. There is so much outstanding, and the trial on this case is going to be very interesting because of how little is known. Other high-profile trials, like Murdaugh, we had more information. In a Darrell Brooks case, we had most of the information. Even in a Johnny Depp Amber Heard, most of the depositions and things had been made public due to the prior trial in the UK. This is a case where we're going to tune into trial and not know what's happening, what the witnesses are going to say, and how they piece this case together. And we're all going to watch as jurors because there's not much information to be had.
And speaking, the question I was going to ask you for a percentage on, I'll just ask it. You don't have to give me a percentage if you don't want to, Emily, but percentage chance that this actually does in fact happen this summer, the trial, that is.
I don't know what else the defense needs. I don't think it's terrible odds that they set a trial date in the summer, but whether that actually goes or not will be different. I think summer is probably a good option for them because the university will be on break. It won't be as disruptive to the community. So I would give it a 50-50 shot that it goes to trial in the summer. I don't know how busy Judge's calendar is and how much time they're setting aside for this trial. If this is going to be a 6 or 8 week trial, they really have to plan pretty carefully for that amount of time to be in trial.
Emily Baker, folks, the one, the only. I think it's obvious when people watch us together that I'm such a fan of yours, just because of how much I've watched your content across multiple platforms. So, all the best to you. I got to make my way up your way soon so that we can get together
Absolutely.
and meet. I'll give you a big hug.
JP, I'm such a huge fan of yours as well. I love what WFLA has done here, and I, like so many, tuned in to all of your live streams with the Petito case. You guys had such ethical and excellent coverage of that case, and the Stream Center made it so interactive in a way that not many outlets are doing, and you really have changed the access of people to news, and I think brought people back to the news in a way that they want to engage with. And I have just a tremendous amount of respect for what you're doing, and I'm so glad that you're doing it.
The respect is overwhelmingly mutual, Emily. And look, as I will be watching back your live stream as you're about to go live and talk about this case as it happens in real time. So I will be watching it in the future. All the best to you on the live stream, and I'll catch up with you
Thank
soon,
you.
my friend.
We'll talk to you soon. Bye, JB.
All right,
Bye,
take care,
everybody.
Emily. Bye bye. Big round of applause, everybody, for Emily. Yeah, just a pro's pro. All right, everybody. We are refreshing this now every 30 to 60 seconds, I've been told. And as of right now, I do not have a feed. We hope to have a feed here shortly. There was a question in the queue. I can continue to answer questions here in the meantime. And this one comes in from Coyote. We'll leave this up here. Coyote, off the subject, but many of us follow you on multiple cases. Please briefly update on Petito versus Laundrie. Yeah, quick update on Petito versus Laundrie. That is going to be happening in May, third week of May, if I remember correctly. And depositions continue. New paperwork has been filed specifically about the deposition process. As a reminder, Gabby Petito's parents suing the Laundries and their attorney, Stephen Bertolino, for intentional infliction of emotional distress, claiming that they didn't do enough when Gabby was missing, accusing them of knowing more than what was led on at the time. That case is still very, very much in happening in May. And so we will, of course, be streaming that. Any hearing and any, of course, any occurrences with that case will be streaming here. And you can follow me at WFLAJB across my socials, because that, I even the smaller things, I will post updates on that from time to time. We wait here for Judge John Judge to go live. And I just want to make sure that that we are still refreshing this, right? Because make sure that this is 100%. We don't have a cookie and staring at just a blank screen, if you will. It's weird looking up a judge's YouTube page, but that's what that is the massive shift now in this case. And no, nothing is live yet. We are still waiting for him to actually click on the live button. You know what's interesting about this too is that there's no activity on this account, which basically means that when after the live stream is over, the video is no longer there. So as far as archival purposes and people being able to, what if you can't watch it live? What if you're somebody who works Pacific time zone especially, and you can't watch it until afterwards? It sounds as if, and it appears as if, it might be a situation where it's one time, it's streamed out live, and then poof, it's gone. But that's why, again, us being able to distribute it, it'll look, if it's live streamed anywhere, it's going to live on the internet somewhere. It'll live.
They said that they were making the YouTube channel for just this purpose, just for this case. So there wouldn't be any other material on the page there, JB. It would just be this case. They're not going to delete them, I don't think, after the lives are over with, though, or after the videos. I think they'll probably just go into a video spot. It'll probably be marked Bryan Kohberger or something. I don't know.
Live on WFLA's pages. It'll live on elsewhere as well, but still no live stream just yet. Let's go back to some of the comments that are coming in. The only comments that I see here in the stream center are if you use hashtag HeyJB. That's literally the only thing that
I'm just making it
pops
loud
up here.
or fast forwarding it.
Kita Lou. Hashtag HJB, will there be an interview with the suspected killer? We've heard every other point of view, but his. It wouldn't be an interview. It would be testimony. And that would be, of course, absolutely massive in this case, no? If Bryan Kohberger took the stand. Now, as a reminder, when he was given the opportunity to enter a plea in this case, he did not enter a plea. It was a plea of not guilty that was entered on his behalf. So he did not speak in that moment. So what his legal strategy is and whether or not that legal strategy includes him taking the stand, that, of course, remains to be seen. There is so much more surrounding this case that we do not know on both sides, really, but especially on the defense side, but so much that we do not know, as Emily said. You could hear even Emily being a lawyer and understanding how this game is played when it comes to a criminal case this high in profile. She understands the inner workings, but even she, having covered so many cases, expressing frustration as to how little we know at this point in the process. If a trial is to occur in 4 months from now, you would think that we would know more at this point. We don't, and that in and of itself is abnormal, an anomaly of in some respects. Again, as a reminder, if you're finding the live stream here, when the live stream actually begins, I do not provide commentary. That is not my role here. The Stream Center's purpose is to be able to provide feeds and a respectful place for you guys to chat amongst yourselves. We have our terrific team of moderators that are helping keep our comment section kind and respectful to all. I have no idea if Judge John Judge knows how to turn off the YouTube chat. But if he doesn't, it's I can assure you, being somebody who does a lot of live streaming, that it's going to become a zoo real fast. And but again, today very much a trial run because this is the first time the pool camera is not part of the equation, folks. The media is not providing you with that inside the courtroom coverage. This is all coming from the court. And we just here are then distributing that signal out across the internet through our appropriate channels, through our respective social media channels. If you want to go watch it on Judge's page, it's right there on your screen. You can go there and go right to the source, or you can get it from us, and you can engage in the chat as well. Also, should point out that after this is over, we'll be coming back here and talking about what we have learned, reacting to the potential of perhaps the scheduling conference setting a date if it does get to that point. We'll kind of put a bow on things and talk about what we learned, any surprises, twists, turns. But as of right now, we are still waiting on this to go live. How many people we live for? Okay, about 10,000. Let's see here. Lil Patty, hashtag AJB. If Alex Murdoch, AM, gets a new trial, are you going to stream it? If we look, we do interactive coverage of trials, right? We try to bring you guys in. We try to also run polls as well. We try to make the live streaming experience very much one that includes you. So if you guys, it all depends on how much, how many requests that we get. I mean, I'm talking about everything from emails to heyjb@wfla.com. That's really the main way. Also, as well, DMs. Like we pull it all together and we say, okay, this is what people want the most. This is what people really are focused on and interested in. We can't cover every trial, and also doing an entire trial is a massive undertaking for any news operation. It's every day. It's sometimes you go beyond the normal hours, if you will. So we have to be selective in which trials we cover, but enough people responding to something or emailing us. Look, we go by what you guys want. This is very much a channel for you. Interactive journalism is all about spotlighting you guys. It's not about our opinions. It's about your opinions and reacting to what you guys have to say. I'm really glad you asked this, True Crime Junkie, how long this hearing will last. I don't know. And I have no idea. I'm here East Coast now. The time is 4:03 Eastern. And I have no idea how long this is. I'm here for the long haul. Now, you would anticipate that they would not go beyond 5 o'clock Pacific. That would be, of course, 5, 6, 7, 8 o'clock Eastern time. But look, you have things to get through today. You got to make sure that these motions are handled procedurally. And so we've covered some pretrial motions that are expected to go on for hours that take 20 minutes, some that are expected to go on for 20 minutes and can take 6 hours. We have no clue. No idea. The scheduling conference, which is probably what you're here for, the scheduling conference is when they would actually set a trial date. That could be 5 minutes. That could be, all right, does this work for you? Okay, does this work for you? Looking at the prosecution and the defense. All right, is your calendar free at this time? All right, you're not on that cruise vacation that you're going to be taking, in June. Oh, okay, good, perfect. We'll schedule it for then. It's just a matter of figuring out a time. Yeah, no, Gypsy says after the hearing is a scheduling conference. Yes, we very well might get a trial start date. Now, look, a trial start date is never set in stone. It's not engraved in concrete. We see delays all the time. The most interesting thing about this is that there has been this overall feeling that the courts do not want this to be done at a time when class is in session at the University at Idaho, that ideally you would do it when there is it's a 6-week trial. So 6-week window, including jury selection. And the only 6 weeks that are somewhat inactive over the course of the school year is the summer. So if you don't get it in summer 2024, as in a few months from now, you're looking at the potential of this trial being pushed back to summer of 2025. People are going to be upset. People are, you would imagine that also the parents of the victims, the parents of Kaylee and Maddie and Ethan and Xana are going to be, upset. But this is what happens with criminal trials. Sometimes they get extended into not months long, but years long as far as the wait as to when it could begin. Any other questions? We're waiting on Judge John Judge to go live. Just refreshing everybody. Justin is asking on Twitter /X, #KJB, what exactly is this hearing for today? We talked about that at the beginning with Alex Capriello, News Nation national correspondent. But in essence, the first hearing, which was behind closed doors, was about a motion to dismiss the indictment. And then the second one that we're going to be hearing at great length in probably a matter of minutes from now is to reconsider a previous denial of dismissing the indictment because of inaccurate instructions, inaccurate conduct, if you will, the allegation of inaccurate instructions being presented to the grand jury. And as I understand it, the way it's all about language, arguing that the grand jury actually should have been told. They're arguing that to find proof beyond a reasonable doubt, rather than the grand jury ought to find an indictment when all the evidence before them taken together, if unexplained or uncontradicted, would in their judgment warrant a conviction by a trial jury. It's tomato. You could argue it's tomatoes and tomatoes, but it all depends on how Judge John Judge sees it. If procedure was not followed, then he could reconsider the refusal to dismiss the indictment that was handed down by the grand jury to Bryan Kohberger. But this is all considered a massive long shot. This is all considered by every attorney that I've spoke to on the phone or chatted with via text. This is all considered to be an attempt to just try everything that they can, making sure that they are crossing their T's, dotting their I's, so that every legal option is explored to get this trial thrown out before a trial it happens perhaps this summer. Hopefully that makes sense. Guys, if I'm ever talking in a different language, if I'm not ever making sense, like you could tell me. I try to make this as easy to understand as possible. But even then, I need sometimes a translator like Emily or Peter, the lawyer coming on here to help me figure out because self-admittedly, legal jargon, sometimes we go so much into the weeds, I get lost and I can't figure out exactly what we're talking about anymore. Sometimes legal cases can get quite complex and so granular with some of the motions that are filed and then secondary motions and then appeals. Sometimes it can make your head spin, but that's why we have brilliant attorneys that are able to help us understand what's going on. The time is now 4:08 Eastern, 1:08 Pacific. No live stream yet from Judge John Judge. Now you heard Emily say, this is very, very interesting. Emily said that there was an attempt earlier this week, I think she said earlier this week, to go live, and it worked. So it was like a test, if you will. Like, hey, does this work? And so, look, as someone who does streaming for a living, I can assure you that there's 1,000+ ways it can go wrong, from your RTMP signal, from your camera feed, not having any audio, to this firewalls coming into play. There's so many different things that can, or it's just as simple as, look, they're finishing up lunch after the previous hearing, and they're gonna just go live whenever they actually are ready to go live. But the time is now 4:10 Eastern and nothing. Some kind comments in here. Thank you. I see the kind comments. I just don't put them up on screen too much, you guys, because this is very much about your opinions and questions, and not. But some of the people who are putting in some really nice things. Thank you. That means a lot to us. It means a lot to me. I'm up on screen too much, you guys, because this is very much about your opinions and questions, and not. But some of the people who are putting in some really nice things. Thank you. That means a lot to us. It means a lot to me. Thank you. All right. Chelsea says, hey, JB, refresh. Okay, we're Chelsea, we're refreshing. Chelsea, one of our great mods. We're refreshing.
And Ms. B. So we're here. This is an open case.
I beat
You
JB.
probably know we had a closed hearing this morning, and that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct. We made some changes, and you probably also know that we are streaming now, and that is on a YouTube channel. If you don't know that, you can go to the Supreme Court website, and you can get that channel if you don't have that already. So you don't want to be on a camera, you probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today, we are addressing reconsideration of the order denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So and a stay of proceeding in the case. I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Thank you, Your Honor. I'm gonna, I guess, be succinct since we argued.
Oh, good God. We're not
almost the very
hearing
same
him
thing this
again,
morning.
are we?
But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to
Here we
appeal,
go, going back in
we may
time.
never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if trial is set out as far as we think
Bill
it
ain't
ought
got
to be,
time for this. He wants to
that
retire.
an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye.
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first 2 factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logston? Reply?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Stop being dramatic. They haven't killed anybody there in 40 years.
Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Knight said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but The court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood of possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule.
Oh,
So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go
defeated.
first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want you, Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that, and that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations. We have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
Thank you, Mr. Taylor.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, council and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to
She
be
just
done
wants more
to present
money.
to the court.
She's getting
and
paid
council in
$200 an
support of
hour.
that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned.
But I thought they didn't have any discovery.
So, with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at 2 tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Miss Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video.
Better hire some more people.
And we just have 1 of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes.
They've had this
not
since
just
like
1.
April of last
So
year.
that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of.
Ain't nobody going to tell you no for an interview, for a case. Come on now, Ann.
I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well, less than 10%.
We better
of
start
those
working hard.
witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways.
Oh, come
But it's
on.
not just a life story. We're required to go 3 generations back on each side, mom and dad.
They have 4 victims, Ann.
The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents
Get out of here.
are missing. Sometimes they're very old and you have to piece things together. We're working
Very
through
old.
it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in
Well,
it.
they
So
don't
you
need
must
to
open
index
each
it
of
for
those
you,
files and
Ann.
see what you have.
Read
And
it
you might
yourself,
have
index it
police
yourself.
reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day, because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then get them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us, but they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of them.
Okay, so basically, it's not the prosecution's fault, she's saying, for all of this, but it's just the way that the system goes. Okay, let's keep it moving, Nan. Keep it moving.
Those 9,000 tips.
We got what you're saying.
There are things that matter to us in our innocence phase that have come up and been done, and I have to read them and appreciate them and react to them and see what's there.
Oh,
that's
God.
the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June of 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together.
Are you kidding me?
And the more work I do, the
don't know
less
your
I
own
know about
case?
how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
Sure.
I understand this. I mean, I'm aware of amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this?
Let me help
trial
you, help me,
sooner?
help you.
That's a tough question.
No.
If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just
That's
not
why
a
you have a
shortcut for that.
team.
Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend
We might as
every
well just go
possible
to
hour
summer,
on Mr.
2 more
Kohberger's
months.
case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you that.
He's like, whatever.
This is priority for everybody. And I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. And we have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them, and there won't be undue interruptions in the community that could cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first, and not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-rotation, said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Lake Charles County.
Thank you, Mr. Thompson. So you're saying, looking at this
Did he say
realistically and the amount of information, evidence, non-evidence, that might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder. And they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal. It
He's
doesn't
not
come
liking that
back
answer.
for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah. I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. There's going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time.
I'll be retired by then.
We don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal. And that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life without this hanging over your head. So, sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay, Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Well, she's freaking happy. Look how tall BK is compared to that other guy. Wow. I guess I don't know. I guess they're buffering us out of there. But Judge is yeah, I think he was pretty pissed. Not pissed, but disappointed. You could tell that he was definitely disappointed that they weren't scheduling for the summer. It was almost like him and Bill went out for beers last night. And Bill was like, yeah, Judge, we're on the same page. We're going to trial in the summer. And then Bill stands up and he's like, well, maybe she does need the extra time, because he understands that it is a lot of discovery. It's a lot of evidence to go through. But it was kind of funny to me because Judge's like face, he almost looked like at Bill, like, what do you mean, man? Why are you saying those things? So, we want it done right. I remember what was it? What did they do? When I lost my shit. I cried. I think it was when they said they weren't going to trial or something. I literally was devastated. You would have thought it was my child. I said, I even said that. I was like, you would have thought it was my own child. We didn't end up watching it, but I think we heard it or something. I can't remember because I never did watch that hearing. I never ended up going back and watching it. I was like, I'm not watching it. I don't want to see it. I don't want to hear him. I was so mad about it. But now it's getting, getting a little easier. Debbie, I think that's why I cried too. I think it's more for the families than for me. I think it was just like that. We were on the live. Yeah, Debbie, man, that was a bad one. That was, oh yeah, when he waived the speedy trial, thanks. Yeah. The speedy trial. That's when I was upset. Yeah. I didn't like that. Who's Emily? Doodlebug? Sure. I'm not sure who Emily is. I'm like, sure. Did I miss somebody? But it's good to see everybody. Man, wow. 2025. And you know what's going to happen? They'll schedule it. Like he may schedule it for March, but they're going to continue it. Once we get there, well, they'll continue it. Oh yeah, of course. We do like some Emily D. Baker around here. I think it's terrible. Don't think Anne tried. I think that she just said she needed, oh my Lord, she needed more time. She said that she was going to go above Judge's, head there. If he didn't let her have a stay of proceedings to go to the Supreme Court. So we just kind of slid over that today. And then they just decided to, postpone it. It's crazy. It's very, very crazy. So I know there'll be some news stations that are going to come out with some stuff later and all that. But tomorrow, so I don't know if I'll come back on tonight. I may not. I don't know. So because Vincent's he got off work early. He called me like 4:15. He's like, hey, he was all excited. I'm like, hey, I'm on a live. He's like, oh, sorry, bye. But I'm like, no. But I think that I don't know. Britain, yeah, they said, what did they say about the witnesses? What was that they said? Numerous witnesses they needed to talk to that were from out of state, out of town. I'm like, huh. So I might go and listen to this again and see what, I like to see what they say if I miss anything. Especially today, because I wasn't on camera. I was running behind, which I have my camera on now. I don't know if I still have it on or not, though. I put it on for a second and I was like, hey guys, but I don't know if you guys saw me. Yeah, my camera says it's not turning on. Yeah, it's being weird. That's weird. But I'll be on either later tonight or tomorrow. So I want to go back over the Kansas City Chiefs, the three men that were found frozen in the snow in their friend's backyard. John Pensiato, or whatever, however you pronounce his name, the lawyer for the homeowner, Jordan Willis, he came out and did another interview last night with Kumo. So now we have one from Dan Abrams, Ashley Banfield, and Kumo. And then he's done some other like stuff with another like local channel. So what I'm going to do is I'm going to listen through them for like the millionth time. I'm going to write down all the inconsistencies and then we'll go over them. Because I mean, the dude needs a lawyer for as much as he's talking about, you know, as much as he's talking. It's crazy. If you guys haven't subscribed over to my second channel, make sure you do. I'm going to try to go live over there tomorrow because I got some shit to talk about. I got some stuff to say. You know what I mean? You know what I mean? So, and if you don't know what I mean, you'll find out. You'll find out. But maybe they are taking it off of the, I think that the JB was right about them taking them off. Yeah. So they are going to do it live and then it's just going to be gone forever. So I guess, you know, you can just watch the video. The lawyer who needs a lawyer. Yeah, Catherine, really, I mean, he needs someone to tell him to not talk anymore. Don't talk anymore. Just shut it. I mean, that's like, you know, I mean, at least his hair looks like it's a little brushed more in this interview that I saw with Kumo. I haven't got to watch it yet, but I saw that it came on last night. It was like right after our live. They were playing it again, like on the rerun or something. And I didn't get a chance to catch it. So it's just crazy. Yeah, very well done for referral. Yeah, I watched the latest. I watched that Dateline on my way back from California on a red eye. I was like, get the internet. It's on. We've got to watch it. And if you guys don't have those stations in your country, like a lot of people from different countries can't watch like 48 Hours, Dateline, 2020, those kind of things. I do try to stream all of that. We've streamed even like a Roku documentary for Idaho. We have streamed Bloodline from Fox Nation, a few different things from Fox Nation. So, yeah, I always have a bunch of different things for you guys to watch. But thank you guys all for being here tonight. I appreciate it so much. I will see you either tonight or tomorrow. I may take tonight off. You never know. But if I don't see you tonight, I'll see you guys all tomorrow. Have a great day and have a great weekend. And if I don't see you, you just have a great weekend. Also, if you do not, if you don't mind, just hitting that like button and subscribe to the channel before you leave tonight. And I'll see you guys all tomorrow. Bye, guys.